Good afternoon. The task group presents the role and functions of the vocational expert in litigation today. This presentation will be audio broadcast into your computer speakers, so please make sure that your speakers are turned on and the volume is set to a comfortable level. For any state that requires a passcode for CLE credit, today's passcode is vocational. You'll see that I'll be asking you to input that word into the code into the chat feature, which is over here on the right side of your screen. So during the presentation, if you do have any questions, in addition to putting in the passcode when tasked to ask for it, please use the chat feature that I just showed you on the right-hand side. Today, the presenter will discuss the role of the vocational expert, what is included in a vocational expert report, the forms that are utilized, and the types of cases that a vocational expert will address. Today, our presenter is Dr. Bruce Berwick. He holds a Ph.D. from the University of Wisconsin-Madison in rehabilitation psychology. He's a retired professor from Ohio State University and is a licensed psychologist in the state of Ohio. Dr. Berwick specializes in wage loss analysis for personal injury, disability determination for Social Security and workers' compensation, replacement earnings for divorce and employment discrimination cases, reports, depositions, and testimony. He has more than 15 years of forensics work for defense and plaintiff cases. Dr. Berwick has several publications in the area of rehabilitation and workers' compensation and is a member of the American Psychological Association and the National Council on Rehabilitation Education. Once again, this is the role and functions of a vocational expert in litigation. And I'll pass the presentation over to Mr. Berwick, and he can begin.
Well, thank you, Brooke. I certainly appreciate the opportunity to share my expertise and experience with the legal community. And good morning or good afternoon, depending upon what part of the country you reside in. As Brooke mentioned, my name is Bruce Berwick, and I am with Vocational Experts of Ohio.com, which is the name of our firm. It can be found on the web. Once again, that is Vocational Experts of Ohio. And I've been a vocational expert for approximately 15, 20 years in many different venues. As Brooke mentioned, I'm retained by attorneys in divorce cases, personal injury cases, both plaintiff and defense, of all sorts, whether it be motor vehicle accident, product liability, med-mal cases, etc. I also have experience in employment discrimination cases, we'll talk about briefly, as well as lastly, the Americans with Disabilities Act, Title I, actually has to do with employment and reasonable accommodations. I've been doing this kind of work for over 20 years, have participated in both county and federal courts. I also am a regular vocational expert for the Social Security Administration in terms of their disability determination process, Bureau of Workers' Compensation here in the state of Ohio, and then lastly, I've been retained over the last 10 years by the Ohio Police and Firemen Pension Fund, and the pension fund, much like Social Security, is bifurcated into retirement and disability, and I sit on the disability review panel and provide input on the wage earning capacity of policemen, EMT workers, and firemen if they've been declared disabled by the pension fund. With that as a sort of an introduction, we can move on to the first slide, which is choosing a vocational expert. And as many of you well know, choosing an expert is probably the first step in your particular process of retaining what I like to call a fact witness in a legal proceeding. And in terms of selection, criteria generally are training, experience, and certification and licensure. I myself have been through a couple of Daubert challenges and have always prevailed. And I think part of the reason is that I am a PhD with a doctorate in rehabilitation psychology, although being a psychologist and licensed as I am is not necessarily a precursor to doing wage loss analysis and employability. It certainly does help when the psychological aspects or a psych allowance is attached to a disability claim. In terms of overall experience, certainly having been on faculty for many years and taught this subject to many different students at the graduate level, is certainly helpful for me, both in terms of writing reports as well as in courtroom or hearing appearances. Certainly any expert, as most lawyers will appreciate, have to be good educators or teachers to a jury and or a judge or magistrate in terms of explaining our findings, where those findings might come from, the foundation, and as well as the overall implications. So certainly somebody with advanced training in education as well as teaching experience, I think, is a very good prerequisite for a good expert in vocational matters as well as other matters. In terms of certification and license, I am often asked about that. I don't think there's any prevailing certification or licensure that is necessary, although once again, being licensed as a psychologist within the state or as a counselor might be helpful, because the assumption then is that you've had clinical experience working with individuals, helping them to secure employment and adjusting to their disability or limitations post-injury. The other certification that might be relevant is a Certified Rehabilitation Counselor. The acronym is CRC, and that is a professional certification within our field that has to do with mostly master's level individuals who are clinical providers of services to individuals in terms of disability and employment. And once again, that is a Certified Rehabilitation Counselor. In terms of professional organizations that are usually helpful, there are basically two. One is the International Association of Rehab Professionals, which any good voc expert should be a part of. There is a forensics section, and the forensics section is quite active and deals a lot with the roles of a vocational expert as well. Now, life care planner being somebody who is talking about future medical costs after post-injury, whereas, of course, a vocational expert is talking mostly about wage loss and loss of economic opportunity. The second organization or association would be American Board of Vocational Experts. Their acronym is ABVE, and they are also very active in our field, have a fair number of members nationally, hold conferences for CEUs, continuing education units, as well as a very active chat line, which is certainly helpful to the providers themselves. So with those criteria, that's sort of what you should be looking for. And it's also interesting over the years, I've often been asked, what is the difference between, say, an economist and a vocational expert? Whereas a vocational expert is a clinician who sees the individual and, as we will go through, discusses their education and work history and makes an opinion about employability. An economist is mostly a statistician, as somebody who's provided information about a client, might never actually meet the individual because they're not a clinician, and run numbers on overall employability, as well as work-life expectancy. Expectancy is mostly an economic concept having to do with the joint probability that somebody is going to be alive and employed at any particular age, or how long they might still be expected to be alive and to work. So there is a difference between an economist and a vocational expert. There are some individuals who try to bridge the gap between the two. I personally do not. I think it can be somewhat troublesome. It also can open you up for a Dalbert challenge unless you have the proper education and training to be able to do both. But as a vocational expert, I see my role, and I'm mostly retained by attorneys, either plaintiff or defense, to opine on three things: whether an individual can be employed or not, and identifying the particular job title, whether those jobs exist in their geographical area, something they can commute to, which is actually a real job. And then, of course, what does that job pay? Whether it be divorce, employment discrim, or personal injury. Obviously, that information can then be used by an economist to figure out over a lifetime how much exposure there is, and also take into account a discount rate or an inflation rate. So the difference between an economist and a vocational expert, I think, is rather simple and straightforward. But I also think they do complement one another, and I work with many economists throughout the country in terms of taking the information that I provide from a clinical standpoint and doing whatever statistical analysis and work is necessary to come up with that bottom line figure in terms of loss of economic opportunity or wage loss. Moving right along, as you can see in the next slide, the kind of information that you might expect from a vocational expert. I think the most important thing, obviously, is what jobs a person can perform. I am often asked, post-injury or divorce or employment discrimination, is what particular job can an individual be expected to perform, given their education and work experience? What skill set have they developed over the years that might make them eligible to perform the essential functions of a job? And that includes transferability of skills. And transferability of skills is also something that I've taught over the years at the university and continue to use in my practice. And simply put, transferability of skills is where an individual has worked in a certain job, has developed a skill set, and those skills perhaps might transfer to other jobs at a lighter exertional level. I'm often asked about that, about individuals who are in the building trades, blue-collar trades, or perhaps injuries are more prevalent, and they can't do the heavy lifting and carrying as they previously had done. And the question might be, if they can't do medium and heavy work, what other work could they do at either the light or sedentary level? And that's where transferability of skills comes in. A classic example might be your truck driver who might be doing a lot of lifting and carrying of goods or materials, a material handler. They can't do the medium or heavy work anymore, be it a forklift or a truck or whatever. And the question is what else could they do? Well, individuals like that who are knowledgeable of the transportation of goods and the delivery of goods might work out as a work order clerk. And a work order clerk might be your individual who has the manifest and understands where things are going and how they should be stored and received at the loading dock. That individual could also perhaps be a dispatcher. Obviously, in dispatching, there's a lot of knowledge and skills involved in logistics and the ability to arrange things in such a way so that goods or services are delivered on time. And that would be a dispatcher. Obviously, either a dispatcher, which is done at the sedentary level, or a work order clerk that's done at the light level, is something that an individual can do based upon transferability of skills. In any regard, the important thing is that I identify a job, a specific job that the individual can do based upon their education and work experience, as well as their residual capabilities. The next question that the court sometimes looks to me to try to answer is, how many of those jobs exist in their geographical area? Which is an obvious question to ask once you've identified a job that an individual can perform the essential functions of. That particular process in our field is known as a labor market survey. And the labor market survey is nothing more complicated than going out to some websites such as Monster.com or Indeed.com that have job listings. And in these websites, you can make inquiries based upon just two factors. First factor might be job title that you've just identified, and the second factor might be the geographical area that the person has access to, depending upon where they live. And that is usually known as the Metropolitan Statistical Area, or otherwise in the Bureau of Labor Statistics known as the MSA. And there are numerous metropolitan statistical areas across the country, and you can simply put in a job title in the metropolitan statistical area, and what you will get is a current listing of job opportunities that fill those two criteria. And hence, by virtue of that, you know how many jobs might currently exist, how many openings currently exist within a geographical area. The next factor that I'm sometimes asked to consider and provide an opinion on is how long it would take somebody to find such a job. And once again, there are resources that vocational experts can reference and refer to that are collected both nationally and locally on how long it might take to find a particular kind of job. And I emphasize the word kind because it's a rather broad classification of jobs based upon such things as in the professional health fields versus the clerical work field, and those things are usually done by a broad generic work field. But you will have some indication of how long on average it might take a person to find a job. So you might opine that a person can do a particular job, that openings exist in their geographical area, and that it might take somebody 26 weeks or a half year on average to find such comparable employment. And that is usually helpful as well in terms of figuring out exposure or loss of economic opportunity, which is the damages in a lawsuit, of course, when it comes to wages. The last factor, which is obviously a very important factor in the legal process, is what do these jobs pay? And in that particular case, I usually go to the state agency. Every state in our country receives federal money to collect data, also based upon broad categories of what the average salary might be for a particular job title. So if you wanted to find out what the average salary for registered nurses are within a particular geographical area within a state, you should be able to find that. Every state develops its own database, presents it on a website, which can be easily accessed. In all these particular instances, I always try to download the website that I refer to, which is obviously public information, which keeps the report very transparent and beyond dispute in terms of what the findings may be. So, what might we say are the work products, which is obviously a word that I got from the legal community after I started doing this kind of work as a vocational expert. What be the work products of the vocational expert? The first one is to classify the job title. And I might want to emphasize there is a source document that we go to, which is known as the DOT. It is not an acronym for the Department of Transportation, and it's an acronym for the Dictionary of Occupational Titles, which has been developed by the U.S. Department of Labor and actually dates back to the real Depression in the 1930s. It's in its 7th or 8th edition and gets updated periodically when Congress decides that it's time and there's money to do it. And the DOT has a listing of approximately 12,750 discrete and separate jobs in our economy. Over the years, certain jobs have been purged, like steam engine stoker, and obviously other jobs, new jobs in the IT field, information technology, have been added. The important part about the Dictionary of Occupational Titles is it is a tremendous source document for us vocational experts, making sure that we're comparing apples to apples. So that if somebody says that they're a millwright, and we agree that the job duties they had been doing as a millwright are exactly what the DOT describes it as. So the DOT is a way of us making sure that we have some common terminology about what particular jobs consist of. The other beautiful part about the DOT is that each of these jobs are rated on as many as 72 factors. And those factors are known as the physical demand characteristics of work, such as heavy, medium, and light, bending, stooping, reaching, things like that. It also includes general educational aspects that might be appropriate for a particular job. the temperaments, which are the psychological factors that go along with the job, the environmental conditions that go along for a job. So the DOT becomes an excellent soft document that we vocational experts can refer to when we have to make a decision about whether an individual can perform a certain job or not, whether it be brain or brawn. Brawn being the physical capabilities, and obviously the brain being the cognitive capabilities. So as you can see, we use the DOT to describe jobs according to their skill and strength levels. And we'll talk briefly about that a little bit longer, a little bit later. Another thing that I sometimes do is testing in terms of abilities and aptitudes, although I tend to shy away from testing because as I'm sure many of you appreciate as practicing lawyers, testing can be lengthy and time-consuming and costly. And I certainly don't prefer to spend my retaining attorney's money if necessary. So I can use the DOT to actually describe a person's abilities and skills without doing a lot of testing. And that's all based upon the fact that if somebody is vested in a job, i.e. did the job long enough to learn the skills necessary to do it, that they should have certain skills and abilities as defined by the Department of Labor. But sometimes testing is necessary, especially if additional training is appropriate or schooling is appropriate. Retaining source might want to know if the individual can learn a new job, OJT, on-the-job training, and to have the skills or the educational ability to go back to school and get an associate's degree or some sort of certificate if they have to leave their current employment. Measuring earning capacity is all about wages and salary, and as I mentioned, that is collected by the Department of Labor according to metropolitan statistical area. And then lastly, defining the labor market by knowing what jobs are available within a particular job, category or description. Here is an example, the next slide is an example of what we call a functional capacity eval. And this is a very important part of what a vocational expert does. Because really another way of looking at what a vocational expert does is that they bridge the gap from the medical field to the vocational field. They're the ones who bridge the gap from what the medical doctor might describe as the person's condition to the actual world of work, which is why percentage of impairment, or PPI, percentage of partial impairment, according to AMA guidelines, is not always so helpful to a vocational expert. If I know that somebody is 12% or 15% disabled, that certainly is helpful in the workers' compensation arena, because many times in workers' compensation, wage loss, even if it's of a permanent nature, is calculated based upon the permanent partial impairment and their average weekly wage before the injury. Well, that's not always helpful to a vocational expert in tort cases, because really it's not the percentage of impairment that gets us to where we want to go. It's their physical capabilities, physical and mental capabilities that get us where we want to go. And that's where this form comes in, the form known as a functional capacity evaluation form. And as you see, as you scroll through the slides, this thing actually quantifies what people can do in terms of their strength and exertion. Strength is usually a lift carry. Exertion is posture, whether the person has to be sitting while they work, or whether they can stand at least 2 hours at an 8-hour workday, whether they can lift up to 5 pounds, 10 pounds, or 20 pounds, and also how their upper extremities might be in terms of pushing and pulling, bending, stooping, and reaching, and all those physical demand characteristics that are described in the DOT. So you can quickly see that probably the most important thing that a vocational expert brings to the table when it comes to litigation is being able to translate what a person's limitations are in terms of the world of work. And the best way to do that is to use a vocational functional capacity eval that a doctor, a treating source, or an independent medical eval has completed, take that information and related to those 12,750 jobs that we described by the Dictionary of Occupational Titles. Now, in some cases, I don't have to use a functional capacity form because the doctor has already described their limitations in functional terms as part of a medical write-up, as part of an IME, or any other medical procedure that the person had gone through. But in most cases where only a partial permanent impairment has been used, I tend to use the IME.
Bruce, I'm just going to interrupt you for a moment.
Sure.
You probably can't hear it, but WebEx's phone lines must be having some issues because you're coming across quite garbled for the moment. I'm not really sure why. So I just want to apologize to the attendees, and hopefully we can work through it.
Well, I guess, Brooke, I'm concerned. How garbled am I?
Now it's better. I can hear you clearly now.
Oh, okay. Well,
all right. So it just started, and I apologize for interrupting you. I just wanted to maybe, I don't know what's going on. So I can hear you now. If we tend to fade off and it's garbled again, I'll definitely intervene and let you know.
Okay. Well, I'll try to speak slowly and articulate very well, and hopefully that will be helpful. But in any event, what I was discussing was the functional capacity eval, of which there can be either or both a physical or a mental evaluation. And the second form that you see that's on the slide is taken actually from the Social Security Administration. And in the Social Security Administration, they use this form to describe what a person's mental capacities might be for a job, such as persistence and pace, staying on task, dealing with a supervisor, dealing with coworkers, and things like that. And once again, I ask individuals to fill this form out because it helps me in terms of making that selection process to a job that the individual might be able to perform after an injury. And this form is this one that I'm looking at right now on the slide. Is there any, at this point, perhaps we can pause for a minute, and at this point, is there any questions that someone might have that they might want to post regarding the work of the VE before we talk more specifically about the work products?
Yes, Bruce, we do have some questions. This is Nadia from HEPA. So our first question is, how does a vocational expert bridge the gap between the medical information about functional capabilities of an individual and the jobs that they can perform?
Okay. Well, as I mentioned before, that's where the U.S. Department of Labor comes in a soft document called the Dictionary of Occupational Titles. We are blessed in this country, and we're the only country that I know that has an extensive DOT. Canada has a classification system that is not as extensive as ours and has not been developed over so many years as the DOT has. But what the DOT helps us is in taking that medical information that might come from a medical provider or source about the functional capabilities of an individual in terms of that bending and stooping and lifting and carrying, fingering, feeling, etc. And there are actually 21 physical demand characteristics that are listed in the DOT. And there are 11 temperament or psychological factors that are listed in the DOT. And then there's a skill factor which has a code from 1 to 9 listed in the DOT. And it's taking that medical information and using it to discern which jobs a person can or cannot do. And it's simply a selection process, nowadays helped along by computers, obviously. There are 4 or 5 different software companies out there that produce software based upon the DOT, which since the DOT was developed by the U.S. Department of Labor is in the public domain. Anyone can get a copy of the original data set and the updated data set on the DOT and produce a software package that goes through this process of selection based upon deduction. And that is, which jobs can a person do post-injury based upon their limitations as described by a medical professional. And that it can be done both for physical as well as mental as well as emotional. Emotional obviously being the psychological factors, mental being the IQ or skill factors, and the physical being the brawn factors that people have to demonstrate in order to be eligible to perform certain jobs in our society.
Great, thank you. Here's another question. Do you rely on SSI disability application determination as a basis for opining about whether a person is disabled?
Well, that's a very good question, Brooke. And I might want to stress at this point that every disability system is slightly different. It ceases to amaze me, I guess, that the layperson, as well as the professional who might not be so well informed, might not appreciate the fact that every disability system has its own definition of what being disabled means and how that might even be calculated. For those of you who might be familiar with Social Security, for example, much like I am, having been and still are a vocational expert for the Social Security Administration, I had started in 1988. So it's been over 25 years that I've been involved as a vocational expert in Social Security. They have their own definitions of what a disability might entail, how that is to be operationally defined and measured. And that is true for workers' compensation, and it might differ from state to state, because as many of us probably know, that workers' compensation was federally mandated back at the turn of the last century, 1908, 1910, and a federal law that said that every state needed to set up some sort of adjudicatory process to handle work-related ailments and injuries, and hence we have workers' compensation. So every state is slightly different, perhaps, in the way it defines disability. And that is also true with pension funds, such as the pension fund that I'm involved with. They might define disability differently. So it certainly behooves the person to find out what the criteria might be for any particular disability system. But it is not a proven entity that if somebody is disabled, say, in Social Security, that they're immediately disabled in every other venue. Each of these venues might be different. And certainly tort cases are true as well, even though the specifics of tort cases might vary from jurisdiction to jurisdiction. Obvious bottom line is what has been the wage loss, and can you quantify that wage loss and somehow justify it? And the vocational expert is extremely helpful in this latter case because they can talk about specific jobs that a person can or cannot do. They can also talk about labor market access, and labor market access is generally speaking the percentage of jobs that a person could have done prior to the injury versus the percentage of jobs that are available to them post-injury. And then be very specific and talk about a particular job, that if a person was a millwright, as I indicated, prior to injury, and now they can no longer do that for whatever reason, what other jobs can they do, if any? Do those jobs exist, and what do they pay? So, it's important to appreciate the fact that every disability system is different, which is why there are attorneys that specialize just in Social Security versus workers' comp, versus personal injury, versus Veterans Administration, versus pension funds. And that's a very important distinction to appreciate.
Okay, and here's our last question, Bruce. Can a vocational expert opine on issues regarding loss of earning capacity, i.e. loss of employability in the future due to injury or shortened career span, etc.?
Well, yeah, obviously that's the bottom line question from a damages standpoint. lost wages is basically just the amount of wages a person perhaps has lost when they're off work, or maybe they've had to take another job and have reduced earning capacity. You simply can run the numbers. The loss of economic opportunity has more to do with the overall future and what jobs a person can continue to do, and what the difference in salary might be. And that's where a vocational expert as a clinician comes in, because they meet with the individual and go through a series of steps in developing that report. And I think that is the next set of slides that we have to go through, is a set of slides that have to deal with the steps. Now, this classification of jobs is a chart that's in the PowerPoint presentation that is directly from the DOT, showing it's a cross tabs, tabulation based upon skill on the left-hand side, as well as exertion across the top. And you can see that there are 12,761 jobs in the DOT, and you can see how that breaks down cell by cell. And that's the way in which we calculate labor market access. Obviously, when a person is initially young, they have access to all 12,761 jobs, because the assumption is that they'll be able to do all the work no matter what the exertion might be, and they might be able to go all the way up to medical school and be a doctor, or a law school and be an attorney, and hence their skill level is going to be anything to the top of the chart. Obviously, after an injury, you can decrease the labor market access just based upon percentages. So for a person might have had percentage available to 60% of the jobs prior to an injury, and after the injury they'll only have access to 30% of the jobs, regardless of what the salary is, and hence they've lost 50% of access to the labor market. So you can use a chart like that to talk about labor market access. Any other questions, Brooke, or should I go on to steps in developing a report?
Nope, no more questions at the moment. You can continue.
Okay. Well, what I would like to do now is go through what a typical, or what should I say, customary vocational report might include. It might not include it in this particular sequence, but at least in the reports that I have developed over the years in my work product, this is what I generally try to do. And the first step in meeting with an individual is obviously classifying their past relevant work. And that could be using a resume, or it could be meeting with the person and getting the person to describe the jobs that they did. I've done both. Obviously, if I'm not meeting with the individual, it could be based just upon a file review, and it could be a person's resume or a person's work history. And basically what I want to do is classify the past relevant work, once again, to make sure that we're all talking about apples to apples, or oranges to oranges, or millwright to millwright, or rough carpenter to rough carpenter, et cetera, et cetera. The next step, after classifying it according to job title, is to look up to the code of the DOT. And every job of those 12,750 plus jobs that the DOT has a 9-digit code. I won't go through the particulars of the 9-digit code, but that 9-digit code makes sure that we classify every job according to its major responsibilities. The most important aspects of that classification are the skill and exertion level. And the skill is an SVP code, and that acronym, SVP, is Specific Vocational Preparation. So in essence, you basically have unskilled work. A person can learn through demonstration only in 30 days. You have semi-skilled work that can run anywhere from 90 days to a year. And then we have skilled work, anything that would be greater than a year to 2 years to acquire. And it can be a combination of both education and on-the-job training. It doesn't necessarily have to be school-based learning. But what the SVP code tells us is whether the person is dabbling in unskilled work, semi-skilled work, or skilled work. And that helps us in that analysis of transferability of skills. Obviously, if a person's work history is all unskilled work, i.e. they had obtained no discrete and separate skills during their lifetime, then there's nothing that you can transfer to. The person has to have had at least semi-skilled or skilled work to do a transferability of skills analysis. The other important aspect besides the brain, which is the skill, is the brawn, which is the person's exertional capability. And a person's exertional capability, to keep it simple, the way the Department of Labor has classified work over the last 80 years, is based upon posture and lift and carry. Lift and carry is the more simpler one because that simply has to do with poundage. How much pounds are you required to lift and carry as part of your job? 0 to 10 pounds is considered sedentary work. 10 to 20 pounds is considered light work. 20 to 50 is considered medium work. 50 to 100 is considered heavy work. And anything above 100 is considered very heavy work. And that is what's listed in the DOT based upon the job analysts, the people who went out and actually analyzed these 12,750 jobs based upon the lift carry. The second aspect of exertion has to do with the posture that you're supposed to assume while you're doing the job. Whereas in lift carry, it's anything up to 10 pounds for sedentary. A sedentary job is done mostly sitting, i.e. the person is going to be sitting at least 6 hours out of an 8-hour workday, and hence the job is sedentary. A job is light when a person has to stand for at least 2 hours or more than 2 hours out of an 8-hour workday. And of course, in the light job, up to 20 pounds, you have a lot of sit-stand jobs where a person has the option of either sitting or standing. But in either case, the person is going to be on their feet for at least 2 hours, 8-hour workday, and hence it's not sedentary. The other important aspect about sedentary is light is the use of foot controls. The person has to use foot controls, and obviously automatically it becomes a light job rather than a sedentary job. The next area in posture happens to be medium-level jobs. And in medium-level jobs, most of it is your bending, stooping, climbing, crawling, all those posture things that you might have to do if you're in a blue-collar job or some job where simply sitting and standing and walking is not the only posture you're going to assume. And that is true with heavy and very heavy work as well. So as you can see, the beauty about the DOT and using that to classify work is that you can very quickly determine whether a person's work history is skilled and the exertion that they have assumed. The second step in developing my report has to do with past education. And once again, as a clinician, a person who's trained in evaluating somebody else, meeting with an individual, I go over their past education. Whether academic level of accomplishment, whether they dropped out of high school, completed a GED, graduated from high school, had some college, completed an associate's degree, completed a bachelor's degree, or what we call then a professional degree, something like a jurisprudence, MD, or PhD. And then, of course, we need to find out if they have any special licenses or certificates, which are very important for employment, especially skilled employment, whether it's a registered nurse, a certified public accountant, or a financial advisor who's got Series 7 and Series 11 certification. And then lastly, the vocational capabilities might be based upon some testing and assessment, and I do some brief testing in some cases, once again, to determine whether individuals can learn new skills and how quickly they might be able to pick up on those skills. The next step in developing my report is going to that functional capacity evaluation, or medical reports. I'm not a medical doctor, so I don't need all that voluminous medical stuff that a lot of attorneys sent, especially the daily SOAP notes on how well people are doing from the nurse's station. Basically, what I like to see is the accident report. Obviously, I know what caused the injuries, although I never get involved in causality, and I'm only about damages. I also like to take a look at any post-surgical reports, because the post-surgical reports usually summarize what procedures were done and what perhaps some of the limitations from those procedures might be. I always like to look at the hospital discharge summaries, because the hospital discharge summaries are extremely helpful, once again, in functional capabilities and expectations. And then I also like to look at any PT and OT services that we're providing.
First,
yes.
I'm going to interrupt you and let the phone line calm down for a minute because it's a little garbled again.
Okie dokie.
So we'll just give the phone line a minute to catch up. Thanks.
All right. And that's true for both physical and psychological limitations. So if psychological allowance or somebody has some PTSD or depression or anxiety because of what they went through, certainly we can handle that as well. And it's very interesting in divorce cases, which I do. In many cases, at least here in Ohio, spouses cannot be purposefully unemployed or underemployed during a domestic situation. Very rarely do I get involved in medical information. In those particular divorce cases, it's usually just straightforward education and work history that might determine what an individual can do, whether those jobs exist, and what do they pay. And obviously those facts are helpful to the adjudicator in terms of deciding alimony, both spousal as well as child support. So the medical aspects don't always come into play, obviously, in a divorce case. And they also very rarely come into account in an employment discrimination case. In an employment discrimination case, where the most important criteria is whether somebody can obtain comparable employment or not after they've been discharged, very rarely is there a medical component. But once again, in employment discrimination cases, being able to classify a person's past relevant work, defining what their skill base is, articulating what jobs they can do, and then determining whether those jobs exist in the geographical area, what they pay, and how long it might take them to find such a job, is extremely helpful to the court in terms of adjudicating employment discrimination cases as well. So I've been involved in a fair amount of employment discrimination cases. Likewise, Americans with Disabilities Act, Title I, requires such things as a reasonable accommodation that does not produce an undue hardship for an employer, and the vocational information that I know about the world of work and adapting to essential functions of a job can be extremely important. Going on to the next slide, conducting transferability. I talked by that. We can enlist jobs by work field. We can identify those jobs by a specific DOT number, and then we can identify whether those jobs are available within a geographical area, the expected growth for those jobs, which is also known as the occupational outlook. And that kind of information is extremely powerful and helpful to the court, so that in situations where individuals might proclaim that they're unemployable or that everybody in their neighborhood is unemployed because of a poor economy, one can certainly find certain jobs that are available if reasonable. And again, I do a fair amount of plaintiff as well as divorce work. Steps in developing a report, and the last step, which is obviously the most important step when it comes to damages, which is what a vocational expert is all about, not causality, is identifying job salaries. And salary is something else that in and of itself is not always easy to determine. There are a fair number of private sites out there, such as salary.com, as well as public sites that have salary information on it. I happen to like the public sites in part because I can reference those sites. I can download them and have a web address attached to it, so it's very transparent where that information is coming from. And in terms of job titles, sometimes jobs, salaries, and titles depend upon years of experience and education. Here in Ohio, the Ohio Bureau of Employment Services collects job information and salaries based upon entry level, which is about the 10th percentile, the 25th percentile, which is somebody who's a newbie but maybe has a year or two of experience, the 50th percentile, which is obviously the median, which is what I prefer to use rather than the mean, and then the 75th percentile for people who are experienced. So you have different gradations that you can use to indicate a person's expected salary based upon the number of years of experience they had or their level of education, or both. And that certainly is helpful discerning the difference in salary capabilities. Now, obviously, in some job titles, such as a retail clerk or even a customer service rep, the difference between the 25th percentile and the 50th and 75th percentile might not be a lot. However, in your more skilled jobs where the salaries are higher, there is a significant difference for attorneys and CPAs and veterinarians and especially medical doctors in terms of what a medical doctor at the 25th percentile within a certain specialty might earn versus the 75th or 90th percentile. So that stuff is important. And then lastly, what I like to do is also compare an individual's earning capacity to Census Bureau information. And I emphasize Census Bureau information because in Census Bureau information, you're just dealing with age, education, gender, and ethnicity. So if the court wants to know what the potential salary might be for somebody who's between the age of 40 and 45 with only a high school diploma, happens to be a female, a white female, I can, at least here in Ohio, find out what the Census Bureau says about that individual in Ohio. And that's usually helpful as a general parameter that regardless of the years of experience in a particular job title or the job title they had or the years off that they had as a hiatus from employment, such in divorce cases, I can indicate that a person's salary is lower than, equal to, or expected salary is lower than, equal to, or greater than other white males, for example, or white females of a particular age and a particular level of education. And that is usually helpful to have some sort of parameter to go by, mostly in divorce cases and in employment discrimination cases, perhaps more than personal injury cases. And then lastly, in personal injury in particular, I might be asked to calculate the loss of earning potential. And that loss can simply be the amount of money they were making pre-injury, which is reported either in their earnings report as part of the Social Security statement that they get on an annual basis, or they can now access on an annual basis, since the Social Security Administration is no longer sending printed copies out. You can get a copy of a person's earnings record, which simply shows the year that they worked and how much they made that year, versus what they now can make post-injury. And that information, once again, is very powerful to the court. That is the kind of information I send on to the economist that can then give the retaining attorney a bottom line amount in terms of wage loss, considering such things as work-life expectancy, benefit package, expected overtime, if any, things that can be discerned from a file without seeing the person in particular. And that wage loss ends up being an important barometer for the amount of damages that might be expected in a case and this is true for motor vehicle, med mal cases, product liability, or any type of case in which a loss has been incurred. And so as you can see, the role of a vocational expert is very important to attorneys. And my recommendation, obviously, is to find a vocational expert in your area that can be helpful in determining lost wages or loss of economic opportunity, whether that vocational expert can do everything from soup to nuts, or even discern a portion of employability. But rarely is an individual going to be what's known as PTD, permanently totally disabled, although in some cases there might be. An opposing side might assume that individuals can at least do something, whereas the vocational expert can certainly point out that their residual capabilities from a functional standpoint are not consistent with any competitive employment for various reasons, which is why I've been retained, generally speaking, from plaintiff attorneys as well as defense attorneys. And to me, it really doesn't matter because whatever the facts are, that's what I go by. So with that book, I see we're closing in on 3 o'clock. I don't know if there's any other questions that people might post or indicate they might be interested in.
We do have a few questions here. First question is, as a source document for the formulation of an employability opinion by a vocational expert, what is the purpose function of the Dictionary of Occupation title?
Well, very good question. And that DOT, Dictionary of Occupational Titles, once again, is a very important source document to our vocational experts because it defines exactly what a person would have to do given a particular job title. And the DOT is excellent because it has these action verbs that say whether a person has to analyze, transports, transfers, and that's where the gerunds or the action verbs come in describing what a particular person does. So if we feel that the person is a millwright, you and I are both talking about the same thing. Very interesting, the Dictionary of Occupational Titles, for example, has somewhere between 12 and 15 different drivers. There's a delivery driver, there's a courtesy driver, there's a dump truck driver, there's an over-the-road driver. Each of these drivers are quite different in terms of their responsibilities and essential functions. There's a hook and drop driver, somebody who does no loading and unloading of materials or goods. So that Dictionary of Occupational Titles is a standard by which we can all agree on. That's number one. Number two, and equally important, is those physical demand, mental, and psychological aspects of a job, or those 72 factors that jobs are evaluated or have been evaluated by job analysts. Their job analysts are the individuals that go out with a rating sheet, actually view a person doing a job, and rate what that job consists of in terms of their physical demand characteristics, in terms of their skill and intellectual capabilities that are required. So therefore, the DOT becomes an excellent source document that we use in our field.
Okay, we're going to take a brief breather here because we're getting a little garbled again. We do have a few more questions, and I know that I recently put into the chat feature for everyone to put in the passcode. If you could just do that one more time for me before the end of the presentation. The next question is, how does a VE determine if there are jobs available for an individual within their physical and mental restrictions in their geographical area?
Well, that's an excellent question as well, and that obviously is a burden that the vocational expert should accept as part of their retainment as a fact witness. And the way they do it is that labor market survey, LMS that they conduct, and that's where if you have a particular job title and you have a particular geographical area, we can find if such jobs exist. Obviously, if you're an inland state and you don't have a major body of water nearby, you're not going to have many jobs as clam diggers or seafarers. Whereas if you're in a coastal city, you might have such jobs available. So it is incumbent upon the vocational expert to not only identify what jobs a person can do, but also to verify that those jobs currently exist and are available. Now, an interesting distinction is I cannot, as a vocational expert, promise that an individual is going to be hired in any particular job, which is their hireability, but I can, in terms of their placeability, help to determine that they have the essential functions to be a candidate for a particular job. And that seems to be the litmus test in most jurisdictions. And once again, I can't prove or promise an individual will be hired, but what I can do is I can indicate that they have the skills and the abilities to perform the essential functions of a job, and that those jobs exist in their geographical area.
Okay, that sums up our questions. We didn't have any other questions. For those questioning about the passcode, unfortunately, I can't give it out. It is something that is necessary for CLE in certain states, and we can only give it out at the beginning of the presentation. So it's really not a big deal for those individuals who are concerned about it. Don't worry about it if you didn't put it in. Just as long as we get a few people that paid attention to it, it's not a problem. We appreciate your time, Bruce. I'm just going to take the presentation, switch it back to TASA. Like I said, CLE information. This webinar is eligible for CLE credit in Minnesota, Missouri, and Texas, and it's currently pending in Illinois and New Jersey. To ensure that you receive your CLE credit for today's presentation, please be sure to complete the survey that comes up in your browser at the end of the presentation. The TASA Group, in addition to being your best source for testifying and consulting experts, we also offer e-discovery and document management solutions, our free interactive webinars, and research reports on expert witnesses, the challenge history report, the professional sanction search, and the expert witness profile. Again, we thank you for your time and attendance today. We will be sending out a link to an archive recording of this webinar tomorrow morning. The archive recording will also be posted in TASA's Knowledge Center. If you have any follow-up questions or comments, please feel free to contact our Assistant Vice President, Carol Kowaleski. That's the end of our presentation today. Bruce, thank you again for your time. It's greatly appreciated. And we hope everyone enjoyed the presentation. Have a great day.